The Federal Trade Commission's amended Children's Online Privacy Protection Rule, published April 22, 2025, requires full startup compliance by April 22, 2026, the first substantive update in over a decade. The amended rule expands the definition of personal information to include biometric identifiers, such as fingerprints and voice prints, requires separate verifiable parental consent specifically for third-party disclosure used in targeted advertising rather than treating that disclosure as covered by general consent, and mandates a written information security program with defined data retention limits. A startup that built its original privacy policy and consent flow years before this amendment, when the rule's definitions were narrower, needs to audit that flow specifically against the expanded 2025 definitions well before the April 2026 deadline, because a consent mechanism that was compliant under the old rule is not automatically compliant under the new one. California's regulatory activity in this period illustrates a broader shift toward regulating automated decision-making directly rather than treating it as a subset of general data privacy. The California Privacy Protection Agency's regulations addressing automated decision-making technology, approved by the state's Office of Administrative Law in September 2025, impose staggered compliance obligations. Risk assessment requirements began January 1, 2026. Cybersecurity audit obligations phase in on a revenue-tiered schedule running from 2028 through 2030, and the core automated decision-making technology notice and opt-out rights for what the regulations term significant decisions, covering employment, lending, housing, healthcare, and education, take effect January 1, 2027. A startup using any automated system to screen job applicants, evaluate loan or credit applications, or make healthcare-related recommendations needs to treat that January 2027 date as a hard deadline, requiring a pre-use notice mechanism and a functioning opt-out pathway, not a distant compliance horizon to revisit later. The state privacy law landscape outside California expanded further at the start of 2026, when Indiana, Kentucky, and Rhode Island each brought new comprehensive consumer privacy statutes into effect on January 1st. Indiana's law applies to businesses processing personal data of 100,000 or more consumers, or 25,000 or more consumers, where at least half of gross revenue derives from data sales, and carries penalties up to $7,500 per violation with a 30-day cure period. Rhode Island statute applies at a lower threshold, 35,000 consumers, or 10,000 where 20% or more of revenue comes from data sales, carries penalties up to $10,000 per violation, and critically provides no cure period at all before enforcement can proceed. A startup operating nationally now faces 20 states with comprehensive privacy statutes, each with its own thresholds, cure periods, and specific rights. And the absence of a cure period in Rhode Island statute means a compliance gap discovered there cannot simply be fixed quietly after the fact the way it could be in a state that still offers a grace period. Enforcement activity in the European Union during this same period underscores that the financial stakes of getting cross-border data transfer and consent mechanics wrong have not diminished, even as domestic United States rulemaking absorbs most startup attention. Ireland's Data Protection Commission fined a major social media platform €530 million in May 2025 over unlawful data transfers to China, and France's Data Protection Authority separately fined a major search and advertising company €325 million in September 2025 over consent mechanics in its email products advertising sign-up flow. Cumulative fines issued under the General Data Protection Regulation since its 2018 effective date now exceed €7.1 billion, and a startup with even a modest European user base, reached through organic growth rather than any deliberate market entry strategy, can find itself subject to this enforcement authority the moment it processes a European resident's personal data, regardless of whether the company ever established a European entity or intended to operate there. The unexpected implication tying these developments together is that privacy compliance has shifted from a single point-in-time exercise, typically triggered by a specific regulation's effective date, into a continuous engineering requirement that has to be built into product development from the design stage rather than retrofitted once legal counsel identifies a gap. A startup that wants to deploy an automated hiring screening tool cannot simply consult a lawyer once the tool is built and ready to launch. The California Privacy Protection Agency's risk assessment requirement, effective January 1st, 2026, expects that assessment to inform the tool's design, meaning the privacy analysis has to happen during development, with engineering and legal collaborating on the assessment before the feature ships, not as a final sign-off gate immediately before launch. A related pattern from recent privacy program reviews deserves direct mention. Startups consistently underestimate how much of their actual privacy exposure comes from vendors and subprocessors, rather than their own first-party data handling. A company can build a carefully constructed internal privacy program and still face substantial liability because a cloud analytics vendor, a customer support platform, or an embedded advertising technology partner mishandles the personal data the startup shared with it under an inadequately drafted data processing agreement. Reviewing every vendor relationship that touches personal data and confirming each one operates under a data processing agreement that actually restricts the vendor's own use and retention of that data rather than granting broad discretionary rights closes a gap that internal policy alone cannot fix. State attorneys general have also grown more active in bringing privacy enforcement actions independent of federal agencies. And this trend matters specifically because State Attorney General Enforcement Authority, under most of the newer comprehensive privacy statutes, carries penalty structures that can exceed what companies budgeted for based solely on federal exposure. A startup evaluating its privacy risk exposure by looking only at Federal Trade Commission enforcement history is measuring against an incomplete picture because state attorneys general in Texas, Colorado, Connecticut, and a growing list of other states have brought independent enforcement actions under their own statutes, several resulting in settlements running into the millions of dollars for practices that would not necessarily have drawn federal attention on their own. Counsel building a startup's privacy compliance program needs to map exposure against the specific enforcement authorities in every state where the company has a meaningful user base, not simply against the federal baseline. The children's privacy compliance obligations under the amended COPPA rule intersect in a particularly consequential way with any startup building AI-powered educational or entertainment products, a category that has grown substantially as generative AI tools have become cheaper to deploy and more capable of engaging young users directly. A chatbot, tutoring tool, or interactive entertainment product that a company markets broadly, without specifically excluding users under 13, faces COPPA obligations regardless of whether the company intended to build a product for children, because the amended rule's actual knowledge and constructive knowledge standards for determining whether a service is directed at children have both grown more expansive under recent Federal Trade Commission enforcement guidance. A startup that assumes COPPA does not apply because its marketing targets adults, while its product's actual user base includes a meaningful population of younger users the company has not taken steps to identify or exclude, is operating under a legal theory the amended rule's enforcement history does not support. Data breach notification timing requirements have also tightened considerably across the state landscape, compounding the operational burden a startup faces once an actual security incident occurs. Several states now require notification to affected consumers and to the state attorney general within 30 days of discovering a breach, a considerably shorter window than the 60 or 90-day periods common in older statutes, and a startup without a pre-built incident response plan specifying exactly who makes the notification decision, what information gets disclosed, and which regulatory bodies receive notice in which sequence will consistently miss these tightened deadlines simply due to the internal coordination time required once an incident is discovered. Building this incident response plan before a breach occurs, complete with a designated response team and pre-drafted notification templates, converts a chaotic first 72 hours into a structured process the legal team can execute under pressure rather than improvise. The cumulative direction of all this activity, state legislatures adding new comprehensive statutes annually, California's Privacy Protection Agency actively rulemaking on automated decision-making, European regulators continuing to issue fines in the hundreds of millions of euros, and federal agencies updating decade-old rules, like COPPA with materially expanded definitions, points toward a compliance environment that will keep expanding rather than consolidating into a single simplified federal standard anytime soon. Startups that build privacy compliance as a continuously maintained engineering and legal function, reviewed on a fixed quarterly cycle against the current statutory landscape, will handle this expansion far more efficiently than startups that treat privacy compliance as a project completed once and revisited only when a specific enforcement action or customer demand forces a re-examination. A reactive posture that in this regulatory environment is no longer a viable long-term operating strategy for any company handling meaningful volumes of personal data. Privacy by design. The principle that data protection considerations should be embedded into a product's architecture from the earliest design decisions rather than layered on afterward through a policy document has moved from an aspirational phrase into something regulators and enterprise customers alike now expect to see demonstrated with actual technical evidence. Data minimization at the point of collection. Default settings that favor the more protective option rather than requiring users to actively opt into privacy. And retention schedules that delete data automatically once its business purpose expires are no longer optional best practices for a startup serious about avoiding both regulatory enforcement and the reputational cost of a data handling failure that becomes public. Counsel advising a startup's product and engineering leadership should treat these design choices as compliance infrastructure requiring the same budget priority as any other core product requirement. Because the cost of building privacy protective defaults into a product from the outset is consistently lower than the cost of retrofitting them after a regulator, an enterprise customer security review, or a plaintiff's lawyer identifies the gap first. Interested in analysis about the intersection of corporate law, securities regulation, tech, artificial intelligence, public policy, and the law? Check out my Substack channel, https://theinnovationattorney.substack.com.